absolute bar to a claim. It may not even be at least in federal court, it's definitely not a qualified immunity. There's no immunity at all. In state court, it may now be a qualified immunity as opposed to an absolute immunity because of the amendment of captive. But there hasn't been a case on that yet, so we don't know how that's going to work out. Cool thing, you do have one cool thing, a saving grace in state court, and that's Government Code Section 820.21. Basically, what it says is social workers and people who are involved in child custody disputes with the government, you can't lie, you can't fabricate evidence, you can't exert undue influence to extract evidence, and you have to disclose exculpatory evidence. And if you do any of those things or don't disclose your known exculpatory evidence, all of your immunities under state law are blown out. In fact, I think the lead sentence is notwithstanding any other provision of law. So notwithstanding any other provision of law, if you do the things that are prohibited under 820.21, you're going to lose all of your immunities under state law. Yeah, another thing, you guys, I don't know if you know this or not, for your state law claims, have to comply with the state notice of tort claim statute. You got to serve it within 6 months of the event. If they don't reject, it's deemed rejected as a matter of law within 45 days. And after rejection, you have 6 months to file your claim. So you have some very tight timetables. If you blow them, it's a malpractice issue. And that's another reason we don't like to pursue state claims, because what happens on these cases when they come in, unless you were the handling attorney in juvenile court, you don't have all the information you're going to need to even figure out what all the potential claims are. You're going to have to go through an 827 process, get all the records, start culling through what potentially could be thousands of pages of historical documents to sort of tease out what your various claims are going to be, what went wrong here. That alone, just getting those records, depending on the county that you're in, can take up to a year. So, it's hard to comply with your tort claim statute when you don't even know what your tort claims are. And, so that's just another thing to be aware of with your state claims. I have a more specific slide on 820.21. You guys need a break? We've been going like an hour and 15 minutes. If you don't, I'll just keep buzzing through it because we have a lot to cover and I might have kind of overdone this. It's up to you guys though. No breaks? All right. Specifics, Government Code Section 820.21, I'll give you a general overview of what it is. This is actually the text of the statute. I went ahead and just copied it on the slide. See right there, notwithstanding any other provision of law, civil immunity is blown. And then they list it, perjury, fabrication of evidence, failure to disclose known exculpatory evidence. And the cool thing about this, I haven't gotten the instruction in federal court yet because the federal judges are pretty savvy. They know that the state law immunities, state law exceptions to immunity don't apply to the federal claims. But in state court, you can get this instruction. And this instruction is actually really cool because, think about it for a second. Perjury. What is that? That is a knowing false statement under oath, right? So if you can just prove up perjury and you get your malice, oppression, fraud instruction, all you have to do, you prove up perjury and the jury's looking at malice, oppression, fraud. Well, shit, this guy lied. That's fraud. Oh, okay, there's no immunity on this at all, right? And then in addition, the side benefit of that is now they're thinking about the punitive damages. Perjury, those are all bad, bad, bad things. People don't like that. So it's sort of a cool thing if you can get the instruction, push for it. James W. v. Superior Court. You're from San Diego, Beth. You remember that? The James W. case? What it was a Navy bat, and there was this homeless guy that had broken into his house, taken his daughter out, raped her, and then returned her. And what happened there is social services, God bless them, they got involved, and they accused him of doing it. Dad did it. This is a fantastical story. It can't be real. Dad did it. And they got the child together, the social worker with a therapist, convinced the child that, oh yeah, Dad did this. And this was over a lot of therapy, like a year and a half of intensive indoctrination of this little girl. And the dad got criminally charged. They were going to prosecute him and lock him up. And they had hidden some evidence. There was, if I remember correctly, there was some either blood or semen or something on a piece of clothing that somehow they just lost. But it turned up, they tested it, it was the homeless guy who ended up, he was in jail for some other thing, so they had his DNA. And it wasn't dad, so they ended up dropping everything. The legislature's response to that, because they were the social worker and this therapist, they were lying, they were doing all this bad stuff. The legislature's response to that was 820.21. They said, look, this is bullshit, and we're gonna deal with it. Now the problem is, you look at when 820.21 was enacted, it was like 1996. There isn't a case yet where it's actually been applied. So when you do your search in Lexis to find an appellate case defining it, there's one up in Orange County, but I think they lost that, if I remember correctly. It was a guy named Levinson, is that right? Or have you guys done one up in LA?
No, I was just going to say, the County of Los Angeles, the private litigation counsel that's hired by these specified cases, they, in their papers, I mean, even as recently as the case we litigated settled last November, they just pretend in the briefings 820.21 doesn't exist because of the lack of case law. They say cases have been superseded by it, and they just hope nobody notices.
Right, right. That's the problem with 820.21 is a lot of this 1983 litigation is in federal court. So we know that federal courts are not going to apply state law to a federal claim, either for immunity purposes or an exception to immunity. So you get some kind of tangential discussion of 820.21. I think one of the closest one was Parks. I think it's Parks versus County of San Diego that the 820.21 came up as an issue. It was sort of addressed and discussed as like a sideline, as an interesting tidbit, but not really applying to the federal claims. There was one a couple years ago up here. I don't remember the name of the case, but I don't remember the name of the case. I remember the name of the attorney that brought it, but they had an 820.21 claim, but their problem was they didn't put on sufficient evidence at trial to actually prove it. So that was not beneficial either. Let's see. I think that's enough of that. So, Felder v. Casey. I told you guys about this case a bit earlier. It's cool for a bunch of reasons. Number one, it's the one that tells us that civil rights claims belong in court, so we should file them, and that's cool. But also what it says, I was talking a little bit earlier about the tort claim statute. And for your state law claims, you've got to comply with the statute, otherwise they're blown and you face potential malpractice law, all this stuff. What Felder v. Casey tells us is that it absolutely does not apply, cannot apply, will not ever apply to a federal 1983 claim, whether that claim is filed in state or federal court, doesn't matter. Concurrent jurisdiction means you can file either place, but you're going to apply the federal rules on notice, immunity, all of that. The only thing that we're going to draw from state law is going to be the statute of limitations, and that's generally going to be the general statute of limitations. California is 2 years. I think Arizona's either 2 or 3. I should know this. I have a case going out there. But it's either 2 or 3, and then it goes state by state. Whatever their general like negligence statute is, that's going to be what they're bound by for the statute of limitations for 1983 claims. But you see here, preemption applies. We're going to have another next slide. Same basic proposition is under Martinez, RC, and Felder. They actually all say sort of the same thing. I just use the different cases for different purposes. I didn't want to be citing the same case all day. But basically the idea is, again, we've already covered this, is constitutional violations when you're moving under 42 U.S.C. section 1983. None of these state law immunities are going to apply. None of these state tort claim filing or notice requirements are going to apply. It's all governed by federal law. RC here was interesting because until 2012, the state courts were not necessarily always following Ninth Circuit law on these federal civil rights claims. And the way this came up was a claim of mandated reporter immunity. And what happened on, and it got blown out on a demur. We actually got blown out on a demur. It was against Children's Hospital LA and the county. And what the appellate court said there, they went through the whole CAPTA analysis and the congressional intent, how they changed the statute to engraft this good faith requirement. And what they said is, yeah, that's right. So we can no longer, even in state court proceedings, we can no longer use mandated reporter immunity as a bar to the federal civil rights claims. But they went further than that, and what they did that's really cool is they took all of these cases we've been talking about, all these federal cases, May, Wallace, Green, what's another one, that Rogers, all these cases. And they brought them in, they went through a nice little appendix and discussion of each of the cases and said, yes, state court, you gotta apply the same rules. So all of the federal rules that we've been working with and developing in the Ninth Circuit, the federal courts, were suddenly sort of migrated into state court. We cite RC all the time, and judges, you'll see this, the state court judges would say, oh, well, that's Ninth Circuit, that doesn't apply to me, I get to do my own thing. No, you don't. RC says you gotta follow federal law, federal claims. Another thing that comes up frequently is this idea of exhaustion of remedies. The government's always going to want to come in when you sue for, say you have an ongoing dependency case. I don't recommend that you ever sue while the dependency case is ongoing, because the social workers are going to double down, and that's just going to make it ugly for you. But let's say you did. The government's going to come in, they're going to say, well, you didn't exhaust your state remedies, you're still in process, you didn't appeal, or maybe your case is done and you didn't appeal it. They're going to say exhaustion of state remedies, you didn't do it. That's a bullshit argument. Here's a case, Ninth Circuit, they say no. Doesn't matter if you have state court relief, like your appellate relief or whatever they do in dependency. I don't know if you have like motions for rehearing or retrial or stuff like that there. You don't have to do that to pursue your federal claim. There is absolutely no requirement that you exhaust your remedies. In fact, you can file your federal claim concurrently with whatever's going on in dependency court. Again, I don't necessarily recommend it. I've done it before for other purposes, but invariably what happens is if you're suing a social worker for lying in a court report, while that case is still going on, if you can't get that worker off your case, you're in so much trouble, it's crazy, because they're just going to keep piling on. So you have to think about that. You got to be careful. All right, we finally got to it. I have to make a note to actually move this to the very beginning, because we've been talking about it all day. The purpose of 1983, talked about it earlier, I'm going to buzz through this really quick. There's a case for it. Basically, we want to encourage good government through litigation. That's the idea there, is encourage good government through litigation. All right, elements of a 1983 claim. There's only two, so it's pretty simple. It sounds pretty simple. It gets complex. But you have to show the conduct complained of was committed by a person acting under color of state law. Generally, for our purposes, that's going to be a social worker. There's an effort now in our quarterly group to expand that to these private hospitals and doctors who do examinations, these so-called child abuse experts. You guys may have run across them, particularly at the various children's hospitals. I think here in Orange County, there's a Dr. Wong that is prominent in LA. There's Dr. Imagawa at Children's Hospital LA. She's not there?
She's still there.
She's still there.
She's still there.
I just deposed her, so I think it was like 2 months ago. I'd be surprised if she's gone. But there's a Sheridan, I think a Dr. Sheridan out in Riverside. These are all, people that, in my view, I mean, everybody has their opinion, but they're like carpenters with nails. Everything's a nail, and they generally see child abuse in every corner. So you can't really take what they say very seriously. You got to bring in your own experts and deal with it. But so we've been expanding our I guess, target acquisition, let's call it that, from just social workers and potentially police to include the doctors or the hospitals that do these examinations, or sometimes on their own will implement a hospital hold. There's a recent case, it just got vacated out of the Ninth Circuit, is I think Jones versus County of Los Angeles. There the doctor imposed her own hospital hold on the kid. And that's a big problem. Ninth Circuit initially said, no, you can't do that. That's a violation. But then on a motion for rehearing, they vacated the order, gave her qualified immunity, but seemingly invited a petition for rehearing en banc. And we're thinking about filing one of those to, try and push that ball a little bit further down the road. But anyway, 2 elements: acting under color of state law and deprive the plaintiff of rights, privileges, immunities secured by Constitution or laws of the United States. Again, the cases are there for you. Concurrent jurisdiction. What that means is you can file in state or federal court, but again, we're always going to apply the federal substantive law, even if you file it in state court. Okay, this is sort of an interesting issue. It's duty to intercede that sort of flows over for, anybody here do police misconduct 1983 work? Nobody? Okay, there's a theory of liability when you're looking at police misconduct cases where the cops on scene, where this bad thing is happening, like an excessive force of beating, something like that, if they see the rights of the victim being violated by their fellow officers, they have a constitutional duty to intervene, to stop the violative conduct or the violation. And if they fail to do that, then their liability for the 1983 or the constitutional violation is coextensive with that of the perpetrator. So the same idea applies to social workers. That's how we end up, although there is law on supervisor liability, and that's a little bit different, we do both, where we have a supervisor, and they usually, I think in all counties, the supervisor signs off on the detention report along with the line worker. So you have both of them there signing this report. Some counties it's under penalty of perjury. Regardless of whether it's signed under penalty of perjury or not, they will all testify in their deposition that that report is the primary evidentiary document the court relies on at the detention hearing. So knowing that, the definition, statutory definition of perjury will apply whether it's signed under penalty of perjury or not. What that means is, in addition to potential personal direct liability, the supervisor has this duty to intervene. If she has reason to know, and this doesn't just apply to the reporting, this applies across the board, if the supervisor has reason to know that the client rights, whether it be a child or a parent or both, that the client rights are likely to be violated or are being violated by the conduct of their subordinate worker, they have a duty to intervene, stop it, correct it. And with respect to reporting, they have a duty to correct incorrect or misstatements in reports. So if they discover something later that was wrong, false, omitted, they have a duty to come in and fix it. I never see them fix it. I don't know about you guys, but in my case, in my work, my practice, I never see a social worker come in and fix a report, even when it's a blatant misstatement. I've never seen it. But they have a duty. They have that duty, so that's another potential avenue to hook in other players in your dependency case. If 2 social workers go out to a site, maybe one is just shadowing the other for the day, that happens. And we see a warrantless seizure going down, and the worker's thinking, the other worker, the shadow worker's thinking, wow, this doesn't look right. I don't see the danger here. That worker has a duty to stop it. So just, put the skids on, slow it down, reassess. If they don't, then you can pick them up on this failure to intervene, even though they were not the worker making the decision to take the kid, right? So it's just another way to loop in other targets that you may not necessarily think you have. Did I go for? Oh, okay. Downstream events. Yeah, there's another way. It's we try to cast as broad of a net as we can at the inception, and just get everybody in here who's potentially a player. So what we're looking at is liability for downstream events. Where we see this happening is in the delivered service logs, usually with the case-carrying social workers or the workers that are interacting with the family after the detention hearing. They don't necessarily show up in court, but they're monitoring visits maybe. In fact, that's a good example, we'll use that. The social worker that's monitoring visits with the parents. They're not going to be filling out court reports typically. They're not going to be appearing in court, but they do know that whatever they write in their delivered service log entry is likely going to be cut and pasted into a court report, and the judge is going to make decisions based on what they're reading. So they have a duty to be truthful, honest, accurate, complete in all of their reporting, even in the delivered service logs. If they're not, it's liability for downstream events. It's also liable for setting in motion a series of acts by others which the defendant knows, reasonably should know would cause others to inflict constitutional injury. So they're putting lies into their delivered service logs, which are then getting repeated in the court reports. The court's acting on those. They're liable. At least that's our theory. The next slide is just, where are we? Oh, supervisor. That one's sort of a, obvious. Supervisor's duty is to supervise, right? Make sure that your workers are doing what they're supposed to be doing, not violating people's rights, following the law, following policy procedures. Yeah?
With respect to supervisors, we always try to name them, but so far we keep running the same situation as, oh, my subordinate who I wasn't present for when they interviewed or did this, told me this. I had a good faith belief they're telling the truth, so I just rubber stamped it. Obviously, they don't say that, but I just rubber stamped it because I believe my social workers are honest people. And does that, can you pierce that? I mean, do you?
So you trusted them?
Yeah, they trusted them.
You didn't verify?
Do you find that that falls away easily? Like, we've never
Yeah.
gotten to the point where.
Yeah. Well, I'll tell you what I do, and you can see I've developed this sort of like a standard pattern of questioning in deposition, particularly for supervisors. And what we're looking at is, and you always want to do this, you sort of want to do it very subtly, because if they know where you're going, they're going to mess with you and won't give you the answers that you need to loop them in with the trust but verify thing at the end. But you get them first to admit, yeah, I'm a supervisor. That means I have to supervise people. How do you supervise people? Well, I have to review their work. Well, how do you review their work? Well, I look at the delivered service logs. I look at the allegations. I may talk to some of the other workers to see what their experiences were to make sure all of that is consistent with what's in the report. Okay, that's great. That's great if that's what you actually do. Do you ever talk to any witnesses to verify? No, that's not my job. Okay, good. That's fine. So you go through this whole thing with them. Say, well, how many workers do you have? Oh, well, I supervise eight workers. Well, how many cases on average do they have? Oh, 30 cases. Well, that's a lot of cases. You do this verification for all of them. I can't possibly. So you trust them. Yeah, I trust them. You just don't verify their work. I can. You just don't verify their work. No. That's golden stuff. You play that to a jury, nobody likes that. I mean, we pay these people as taxpayers. You can get on transparentcalifornia.org, and every public employee, their salary, benefits, everything is listed there by year. Look up, when you get back, get on your computer, maybe now, look up whatever social worker you have on a case right now, or their supervisor, and see how much they get paid to not supervise, to trust their workers, to not verify, to lie in reports. You'll be amazed. They get paid very handsomely. In fact, I don't know, does anybody here know of or interact with Charles Sophie? Medical director at DCFS, right? And I had a deposition with him, so I did the transparentcalifornia.org thing, so I could go there and talk to him about how much we pay him to do nothing. I wouldn't say nothing. He actually does some work, but again, I'm on video and I don't want to have to go back and edit things. But the guy gets like $350,000 a year, not including benefits. That's base pay. Plus, he's allowed to work private practice up to 20 hours a week. It might be 10. I think, as I recall, I think it was 20 hours a week private practice, and he does private practice. So you combine that with what he's getting paid on our back. Well, I'm not in LA, on whoever's in LA on your back. And it's crazy. I heard that and I thought, I blew it going to law school, man. I should have gone and been a social worker. These guys make bank. And they retire early, and they get, 97% of their last 3 years highest salary for the rest of their lives. And it's crazy what these people get paid. What I would like to do right now, whether you guys need it or not, I want to take a little break. I want to get a glass of water, and y'all can get up and stretch around and stuff. I've been going for a while. I want to make sure that the blood doesn't all go to your feet.
Oh, you know about me? You know what I mean? Not be negotiated.
Absolutely. Well, no, because she objected. And she didn't
Well, it's recording right now. You don't want it recording.
I understand.
Button, it records.
Well, I didn't notice that. You didn't tell me. You said you push this button.
That's it.
Well, maybe it was recording, but I don't remember it
That's it.
recording.
Supervisory obligation is to train, monitor, and enforce the rules as to the subordinate social workers, the line workers that are out there, in the field. So when you have a situation where you have a failure of training, a failure of enforcement, the supervisor typically will be on the hook, and that's also, we'll get into this a little bit later when we're talking about Monell, but that's also an avenue to bring in another target, which is going to be your big money target. That's your deep pocket. That's the county. Because remember, under 1983, you have your individual claims against the individual social workers or supervisors, but there is no respondeat superior liability for government agencies for the constitutional violations that are done by their workers. You actually have to prove up direct culpability on the part of the government in order to make your Monell claim stick. So this is sort of akin to that, but we'll get into Monell a little bit later. It's a little bit more detailed, a little bit different. Yeah, this is sort of obvious. You'll notice a lot of the cases that we use to develop these concepts, they're law enforcement type cases, police misconduct, or in this instance, sheriff misconduct. And the idea is that way back when, I think it was with Miller v. Gammy in the Ninth Circuit, that was like 2003 or something. What the Ninth Circuit said, up until that point, the governments were arguing, hey look, social workers are prosecutors, we get absolute immunity for everything we do. And that was the rule of law for a long time. With Miller v. Gammy, they went a little bit further. They looked at, I talked about this a little earlier in the day, Kalina, it's a U.S. Supreme Court case. There's also another U.S. Supreme Court case called Antoine. They took both of those cases together in Miller v. Gammy and said, well, look, we don't necessarily, just because of the name or title of the worker, we don't necessarily automatically apply absolute or even qualified immunity. What we have to do is look beyond the title to the function these people perform. Is it something that traditionally in common law a prosecutor would perform, a judge would perform, or some other type of government agent would perform? And there was this tension in the law over that issue for many years until, again, Miller v. Gammy came out and said, look, we look at the function, and if the function that they're performing is investigatory in nature, then we're not going to apply absolute immunity. The best they can do is qualified immunity. Where that comes into play here is with respect to supervisors who are supervising their social workers in the disposition of their duties. We're looking again at the function, which is not judicial in nature, not prosecutorial in nature, it's supervisory, right? So that's going to be something that only gets them qualified immunity at best. But you're still going to have to show, this is somewhat similar, I guess, to the failure to intercede, because the supervisor, remember, their job is to supervise, watch what's happening, verify the work, make sure that the social worker's following policies, not violating people's rights. If the supervisor in the disposition of their duties sees a series of acts by their subordinate that's going to lead to a violation or has led to a violation, they've got an obligation to step in their supervisory capacity and stop it, fix it. If they don't, it's direct liability, it's not derivative. We talked a little bit about this. I'm going to make a note to move it forward because it came up earlier. And that's the venue questions. It's going to depend, when you're looking at these, remember we have concurrent jurisdiction, meaning you can file in state or federal court. You're going to have to take a really close look at your particular venue because there are differences between state and federal court. The most obvious one is state court, you don't need a unanimous jury. At 9 out of 12, that's good enough. I can tell you right now, every one of these cases I've tried, and there's only been a couple, we did not get a unanimous jury on all questions. If it were in federal court, we would have lost, or we would have had a hung jury and retried the case. So you got to think about that when you're going to file one of these things. The government, and this is sort of weird, I've never really understood it, the government will not always remove the case. So if you decide you want to file in state court, you may not, we'll get into the reasons why you may not. But if you decide to file in state court, depending on where you're at and the county contract defense attorney that you pull, they may leave it in state court, which I've never really understood because there's this old adage, it's federal court is where good cases go to die. And that's not totally true, but in a sense, you know, it is. In federal court on these civil rights cases, generally speaking, you're going to get better decision-making on the legal issues pre-trial. Where the problem comes in is during trial, the jury instructions are going to be tough because there are no form instructions that specifically address parental or children's rights in the context of juvenile dependency, so you're going to have to make custom instructions. And, you know, the judge may not agree with our view. In fact, on some issues, likely will not agree on some of the things that we think are right. So it gets a little bit dicey. Federal court's hard if you've got a tough damages case. If you have a good liability case, one good thing about federal court is you can do a partial summary judgment motion. As the plaintiff, you can actually go in and say, Judge, here's my facts, warrantless removal. You know, there was bottle rot, that was their excuse. That's Rogers versus County of San Joaquin. And the judge can make the decision right there on summary judgment, no exigency, bang, you're dead on liability, you're going to try damages. That sort of situation, if you're that clean, federal court's great, because the judge can make that decision. State court, there is no provision in the Code of Civil Procedure that allows a plaintiff to move for partial summary judgment. The only thing you can get summary adjudication on would be an affirmative defense, issue of duty, and there's a couple other, I'm not sure what they are, but you're not going to get, unless the defendant stupidly asserts, you know, exigency as an affirmative defense, then you might be able to summarily adjudicate, you know, the lack of exigency there. But yeah, it depends on the way the defendant pleads their answer. It's just more difficult to adjudicate the legal issues in state court pre-trial. Fees, that's a big issue. State court, a lot easier to get a multiplier on fees. Might be more difficult to get a higher lodestar number, you know, the dollar value of the fee, dollar per hour. But state court judges are a lot more amenable to the idea of, you know, providing a multiplier. Where in federal court with, I don't remember what the case was, but it was Sotomayor that drafted the opinion, and she just completely hacked out the ability of, civil rights attorneys to get fee multipliers except under very, very specific extreme circumstances. So one thing you're looking at in federal court, after you do all the work, do the trial, get your great verdict, you may get a decent fee, but it's not gonna be an incentivizing fee. And that's what we really want, is we want people to be incentivized, not a windfall, but incentivized, getting more than you normally would on your average, run-of-the-mill PI case. We want attorneys to be incentivized to come into the field and do their best work. It's hard to do that if you're not giving a fee multiplier. What else do we have there? Oh, different jury pools. I've got a little blurb on here. You get different jury pools, typically more conservative people on the federal juries. And intuitively, one might think, ooh, conservative jury, I don't like that. But think about it for a minute. If you remember back like in the Bush-Gore days, the big debate, the national debate related and sort of revolved around this issue of family values. And family values, family privacy, family intimacy, family control, those are all issues that are very near and dear to the conservative wing, right? And when you get in front of a conservative jury, you really can touch them very deeply by focusing on, the integrity of family and government interference in family decisions and stuff like that. In both of our, in Fogarty Hardwick down here in Orange County, we had a very conservative jury. We had government workers, we had ex-military, business people, very conservative jury. Scared the crap out of me in the beginning. But that's what all touched them. They all had kids, they all understood, and they were motivated, not just to make, to compensate the client, but also to punish the government and the social workers, and they did it with their verdict. So conservatives are good juries for these cases, in my view. Conservatives are good juries for these cases. Another thing, limitations on discovery. In federal court, you're only going to get 25 interrogatories absent a court order. You're only going to get 10 depositions absent a court order, and those court orders are hard to come by. You have to actually make a showing that it's necessary. You have to show good cause. State court, much, much, much better. You just do a little declaration saying I need more. That's presumptively good enough. And the gates are open. You depose everybody you need to depose. You ask as many interrogatories as you need to answer, or ask as many admissions. So that's state discovery rules are a lot easier to deal with than federal. You have to be much more targeted in your discovery approach in federal court. The state court judges, I talked about this a little bit already, is that the I don't want to say quality, but the attention that you're going to get on your legal issues pre-trial in the federal court is at a much higher level than what you'll get at state court. You got to remember the federal judges, they've got typically 2 law clerks that are really helping them out a lot. State court, those guys are overwhelmed. They're lucky if they have a clerk, and they're essentially doing all their own work, and it's really tough on some of these issues. It gets very complex, very nuanced, and they just do not have the time or maybe even the inclination to do the work it takes to really understand the legal basis for whatever it is that you're pushing in one of these cases. So that's something to consider. What else we got? Appellate court. You always have to consider your appellate court, because it's likely that, at some point, especially if you're fairly new to the area, you're going to have, these cases up on appeal. So what you want to do is look at the decisions of your particular venue. Like here in Orange County, you guys have a great appellate court for these cases. And invariably, if we're here and we have a choice, we'll file in civil complex, and it never gets challenged. We end up staying there. And I feel very comfortable that we're going to get a high level of care by the bench, and if it ends up on appeal, we're going to get somebody, a panel that is really dialed in. They're very good here. You go out to Riverside, completely different story. I would never file anything if I could avoid it There's a few I filed in state court where there's a personal injury claim, like the child rape claim. I filed that in state court, so I think that we'll do better on the verdict than we would in federal court. But if I just have a warrantless seizure claim, a school interrogation claim, or something where there wasn't substantial injury also involved, I would not file in state court out there. The appellate bench is tough on these cases. They do not like people suing social services or social workers, and they'll punish you in their opinion. And it's the same with generally, not all of them, but it's generally the same with the trial court. So out in Riverside, we file almost exclusively in federal court. County of Los Angeles feel very comfortable. They have a very good appellate panel up there for these types of cases against social services. They've come out with some great decisions over the last 5 years. Feel very comfortable filing in state court up there. Don't like a federal court up there so much because generally speaking, not all, but generally speaking, the judges take a dim view of the judicial deception cases. The warrantless seizure cases or warrantless medical exam cases, the federal bench is better on, but you get in there with a judicial deception case, I don't care how juicy it is, you're probably gonna end up in front of the Ninth Circuit on it, probably will get reversed, and then you'll be back down there for years and years working it out. So it's tough in federal court up in LA. San Diego, it's tough, either one, federal or state. It's just a difficult place to be. We don't do a lot of work down there, mainly because it is an uphill battle even on an obvious case. You're gonna end up on appeal, and even on remand, the judges, they may not do what you think they should do. If they don't like your case, they're gonna get you anyway. I think that's it for venue questions. So no, it's not. Yeah, another venue issue. You have to think about federal versus state, not necessarily the locality, is who bears the burden of proving what at trial. State court, you can look at this, it's CACI instruction 3051. The issue of exigent circumstances is the defendant's burden. So remember, presumptively, unwarranted seizures are unlawful, just as a matter of presumption. And I think we have a case for that somewhere in here. It's Welsh versus somebody. But we go in state court, we go in with that presumption that an unwarranted seizure is presumptively unlawful, and the burden then is on the defendant to prove exigent circumstances. And we've already talked about how you do that. It's a very specific test in the Ninth Circuit. Federal court, it's a different story, and it's going to depend on your judge. They have a lot of leeway, there's no form instructions, and the general feeling that I'm getting out of the cases in the Ninth Circuit is that, yes, in the criminal Fourth Amendment context, where we're looking at the application of the exclusionary rule, presumptive, or rather the unwarranted seizures, unwarranted searches are presumptively unlawful in determining whether or not we're going to exclude evidence. But the thinking is, or the reasoning is, that since in a civil case, the plaintiff has the burden of proving that the state conduct was not reasonable, then the presumption does not favor the plaintiff. It just goes away. And the plaintiff from start to finish has to prove all elements, including the negative. So the plaintiff has to prove there was no exigency. The plaintiff has to prove there was a lesser intrusive alternative means of preventing the injury other than seizing the child. All that shifts to the plaintiff. Now that's dependent on what you're able to convince your trial judge is or should be the law. You're not going to get a consistent application from one court to the next. So that's a little bit of a problem. With respect to the imminent danger exigency, what you'll see in your, if you get into these and you start doing depositions, you'll see these social workers saying, well, anything could have happened. The kid had a hemorrhage in their brain, and if I let the parent stay in the hospital, maybe they'd attack him and hit him again. Well, first of all, we don't know the parent did it, right? The social worker is doing what we call speculating about injuries or causes. They can't do that. If they're speculating that some kid may get injured in the next day or two by something a parent may or may not do, that is not sufficient to meet the exigency requirements. You see this all the time. I've got, oh, I meant to mention this actually, it came up during the break. So one thing that we do, there's a lot of pattern questioning that I'll do at these depositions on these different subjects, is sort of lay out a trap, get them into it, and then spring it. And what I do is I videotape all of those, and those are on YouTube. So you can get up on YouTube, they're free. You know, if you don't have anything else to do some Saturday night, get some popcorn and watch these people. And you see that what I'm telling you for those, the pattern questioning, because it's pretty much the same from one case to the next, one county to the next, you know, one social worker to the next. It's pretty much the same stuff that they're supposed to be doing. This is all driven by statute, right, with federal and state statutes, so they should be the same. So you can develop these like trap setting patterns, and then you deploy those, and they work in every case. So you want to look at that, and on this issue of speculative injury, that's something that you'll always want to get into with the social worker. First, what was the specific injury that you were looking to avoid? And if you can't nail them down on that, chances are they're just guessing anyway, right? So that's speculative injury. It doesn't support a finding of exigency. They can't seize the kid without a warrant. Oh, federal jury instruction use notes. So I was talking about the differences between the venues. The use notes, Ninth Circuit model instructions, they have it on their website. You can go look at it, pull it up. They have use notes on every instruction. And now, I checked this, whatever it was, Thursday, before I came up, because I didn't want to tell you guys something that was wrong. But now, for the area of parental rights, children's rights, they don't have an instruction, but they do have a section where they kind of lay out the reasoning and the law that's going to apply in fashioning jury instructions for your particular case. So that resource is there now, and it's actually pretty good. What was the point of this slide, though? Yeah, this was what I was already telling you about, is that federal court, you're going to get saddled with the burden to prove a lack of exigency. But on summary judgment, that's not true. Because remember, on a summary judgment motion, in federal court, the judge can decide these issues as a matter of law based on the evidence. And there, the judge can actually make the decision, oh, you know what, there was no exigency, so you know they'll nix it out, you can go to trial on your damages. Okay, some of this we probably already kind of covered, somewhat duplicative is what it's looking like. I'll take a note on that. But the different flavors of constitutional violations that arise in juvenile dependency cases. This is not the be-all, end-all. I was talking with Mitch up at the water cooler, and he's raised an issue that may also give rise to a constitutional violation. It would sound like a due process violation. That's where the workers in a dependency case, and correct me if I get this wrong, the workers in a dependency case have statutory obligations to disclose, under the rules of court, I think, to disclose exculpatory evidence. They have to respond to discovery, a whole bunch of stuff. That all goes to the issue of fundamental due process, fundamental fairness. And what I'm understanding is that the agency does not comply, routinely does not comply with those obligations, and the juvenile courts, I guess, are not enforcing those obligations. That sounds to me just, off the cuff, like something that may need to be litigated. It sounds like a constitutional violation. It's, fundamental fairness due process issue. So, like I said, this list is not the be-all, end-all. It's just the stuff that we see the most. And it's, the most obvious. That's probably why we see it the most. Unwarranted seizures, unwarranted medical exams, school interrogations, deception in obtaining a warrant. That's where they make false statements or fabricate evidence in a affidavit in support of a warrant application, or they do not include, they omit exculpatory information that would have clarified or ameliorated the issues that brought the family or child to the attention of the social worker to begin with. Then deception and presentation of evidence in juvenile proceedings and injury to children, and custom policy practice. Yeah, we already covered that sort of stuff. Okay, the next slide we're going to skip through really quick because I think you guys got it. Fourth Amendment, constitutional rights, we all share, all parents and children have them. It's the same stuff we've already talked about. Applies This is actually cool stuff. We've already talked about it, but this gives you the actual case sites that supports the proposition. And that's that the Constitution applies the relationship between parents and children and each other. And, you know, there's case law for that. Troxel's sort of the seminal case. Then the Ninth Circuit, Wallace versus Spencer, and Calabro v. Floyd, they all lay out the same basic rules. But that's in the materials, and if you guys need it, it's there. Social workers' duty include. This is a cool idea because we rely on this concept in every single examination of every single social worker. They have duties and obligations. And religiously, I try to use the phrase affirmative obligation because somehow that just carries more force. It's something that you have to do, not something that you might do or should do, but something that you have an affirmative obligation to do. You have to step out of your little box and do it. And juries seem to understand that better than just this amorphous concept of duty. But here, again, it's RC, Children's Hospital LA. That's where we migrated all the federal law into state courts. Parents and children will elaborate constitutional right, live together without governmental interference. Duh, it's, you know, kind of a no-brainer after the development of all the law. Yeah, this is actually, the next one, Calabro v. Floyd, is sort of an important point. And this is what comes up. As the social worker, you know, we all understand the whole purpose for the social worker is to go out and protect children from abuse, right? Pretty simple, straightforward. But they also have a right that's, you know, coextensive and equal to protect the rights, the constitutional rights of the children and the families that they're getting involved with. And where we've gotten a lot of traction over the last few years, and this is going to sort of dovetail into the Monell discussion, is that everybody recognizes these sort of competing obligations, the obligation to investigate and make sure the child's safe, and the obligation to protect the child and the family's constitutional rights, the integrity of the home, the privacy of the family. And there's this tension. And when you depose these workers and you ask them, you know, what is your primary duty? What is it you understand is first and foremost, whatever it takes, protect the kid. And that's it. And generally speaking, what they understand through their training is the constitutional rights. They don't even necessarily know what they are, at least until recently. They didn't even necessarily know what they were or what applies or how they're applied, or that they have an obligation. You know, since 1999, they've had a very clearly stated legal obligation to protect the rights of these children and families. So the way that you address that is with your Monell claim. Since the counties aren't training them adequately on their obligations as arms of government, agents of the government, the county bears direct responsibility. Because remember, we don't get respondeat superior liability for the misconduct of the worker, right? And no jury is going to want to hammer a worker for $3, $5, $10 million. You know, an individual worker who's struggling to make car payments, house payments, you know, feed their kids. So to get the big verdicts, you have to be able to tie the government in. And this is the way you do it, is on the Monell. Failure to train, big deal. Failure to have a policy to address potential violations when they know they need one or should know they need one. Those are very common claims. They all sort of derive from this concept that we have an obligation to protect the kids, but we also have an obligation to protect their constitutional rights. Some of this, again, it's in the materials. I don't really want to bore you guys with it. But there's distinctions between 4th and 14th Amendment rights. We did already address some of it. The main thing to take away from it is that the 4th Amendment, I see this all the time in pleadings that we get when we're asked to help out on a motion to dismiss or summary judgment or challenge the pleadings, is that the 4th Amendment is frequently confused as to who has what right. 4th Amendment is a personal right. the person seized is the one that has the claim, or the person whose property was seized is the one who has the claim. So a parent does not ever have a Fourth Amendment right for the seizure of their child, ever. It just does not happen. It's personal to the child. The parent's rights derive purely from, at least in this context, I mean, the First Amendment may have some application, Fifth Amendment may have some application, but what we primarily focus on is the 14th Amendment. In the context of these cases, the parent's rights, whether it's judicial deception or the seizure, derive from the 14th Amendment. Remember, there's a substantive and a procedural prong. Now, the analysis that we're going to undertake when we're in a court proceeding, when we're looking at a potential Fourth Amendment claim for the child versus a 14th Amendment claim for the parent for the same misconduct, the analysis is going to be the same. So, to that extent, they're they're basically identical in terms of analysis. But remember, parent can never pursue or press a claim for their child's Fourth Amendment rights. We've talked about that, corollary right, equal, identical. Those are the cases that support it. Oh, yeah, actually, I just talked about this. Here's the slide. Jones versus County Los Angeles, 9th Circuit, 2015. Remember, I mentioned a little earlier, that decision's vacated, recently vacated. There's likely going to be a petition for rehearing and bond, and we'll see what happens there. But it doesn't actually matter, because the law they rely on for the proposition stated on the slide is old stuff, and they just sort of, synthesize it down into a nice, clean little, two-sentence package. So you can still go to Jones, pull the law that they rely on, and that's still good law. That's binding in the 9th Circuit. We talked about the next one too, presumptive unreasonable. And it's Welsh versus Wisconsin, jury instruction 3051, and the use notes. Again, anytime you're looking at one of these cases, I'll tell you the way that I do it. I don't so much anymore because I'm more familiar now. But when I first started doing this stuff, the first thing I'll do is go look at the jury instructions, look at the use notes. The use notes are to give you just this wealth of information. And then look at the cases that they rely on in the use notes. From that, you get a pretty good idea, the structure of your issue or your cause of action. You get enough that you can lay out a complaint that should pass muster on a motion to dismiss. Yeah, that's that. Oh, I'll bet you guys thought I was reading this. I wasn't. This is I've said this already in the presentation. This is something that you're going to want to get ingrained into your being, because this will be front and center in almost every deposition you ever do with a worker, a supervisor, a person most knowledgeable, a director, anybody with social services. They don't know the law. They know they should know the law. They know the law generally. And remember, I talked a little bit earlier about how the judges, especially in federal court, they are not going to give your jury instruction that looks like this. This is the law. This is black letter law. You're not going to get that from the jury. So one thing that we do that I think is kind of cool is we're entitled to rely on training, and we're entitled to get testimony on training. And training gets in front of the jury because we have a Monell claim, right? And it may get in front of the jury also to show knowledge of the social worker, their knowledge of the plaintiff's rights at the time they violated the rights. So this is what we do. Let's get into that deposition and say, well, you've had training. Yes. You've had training on warrants. Yes. You've had training on exigency. Yes. What was it? We talked about this earlier. They don't know. So they kind of know generally. So if you can just memorize this standard packed black letter law, say, well, haven't you been trained that you cannot lawfully remove a child from custody of its parents unless at the time of the removal you got specific and articulable evidence to show the child's in immediate danger of suffering severe bodily injury or death in the time it takes to get a warrant? Yeah, I think that's right. That's going to go in front of the jury. You get to play that video, and that's what we do. Is at trial, this last trial I did, it's kind of crazy. It was 8 weeks long. We had 13 and a half hours of social worker videotape deposition that we played to the jury. It was stuff just like that. So by the time the jury gets to closing arguments, they don't need the jury instructions. I've given them the jury instructions I want. And it's come in the form of testimony. So in closing argument, say, well, was there an exigency? I don't know. Let's see what an exigency is. Play the clip. There you go. That's an exigency. Was it there? Hell no. Right? So if you work it out right in your depots and you're able to weave the actual black letter law into the testimony, you don't care what the judge is going to saddle you with in terms of your jury instructions, because you're just going to play the testimony to the jury, and they're going to get it on their own. They're not. These juries are really, really, really smart. People don't give them credit. You know, and in my view on these cases, you want the smartest jury you can possibly get, because they're going to think about it. They care about the issues. They're going to learn the law through your testimony, or through your target's testimony, and they're going to apply it. So that's the way we do it. Talked about this a little bit earlier, probable cause. Remember, this is what probable cause means. I don't really care. We don't really care about that. I'll tell you why. Because Ninth Circuit, in the context of a case against, a 1983 case against social workers for seizing a kid without a warrant, showing the probable cause does not satisfy the burden or the standard they need to meet. So, and you'll see this, the counties will come out and say, oh, probable cause, we have probable cause. Okay, no, who cares? We have a very specific definition in the Ninth Circuit, is that last slide, I'm not gonna read it again, but it's that last slide, and that is the standard. So we don't care about probable cause, they bring it up, you can blow them out. Mabe tells us it doesn't matter. What's imminent? It's actually kind of interesting, because you wouldn't think this would come up. Imminent, right? I mean, dictionary.com, doesn't that tell you it just means immediate? But these county attorneys, they will throw this at you, and they will come up and say it means all kinds of things. Well, no, it doesn't. It's defined by the court. It's very clear. I'm not going to read it. It means impending and all this other stuff. But, again, in the Ninth Circuit, we may care, I'm not sure we do. Because what the Ninth Circuit tells us is that the time within which it takes to get a warrant is the temporal standard that we apply in determining whether or not a danger is imminent. Right, so how long does it take to get a warrant? That is always going to be a major area of dispute in these cases. So what you want to do is you want to get it out right up front in your first deposition. You start asking your workers, have you ever gotten a warrant? Now they'll say yes. 2 years ago they'd say no because they just weren't doing it. Now they'll say yes. Okay, well, how many have you gotten? Oh, 3 or 4. Tell me about the process. How do you do it? Who do you go to? How long does it take? And you get that pinned down. Then you go to the PMK, the person's most knowledgeable, do the same thing. Start getting them pinned down on a time frame, and you're generally going to find out, it varies county by county. LA is 2 to 3 hours. They claim 4 to 6, but it's really not. It's 2 to 3 hours. Orange County's quicker. They actually have a electronic application process. They can probably get it within an hour or 2. San Diego claims it can take weeks. We're going to get that worked out. But so it's going to vary county by county. But again, in the Ninth Circuit, if we're in federal court, we don't care so much about imminent because, again, it's the time it takes to get a warrant. When you're in state court, on your summary judgment process, you may care because the state court judges, remember, they're not going to be quite as familiar with the area of law as a federal judge might be. So you may have to go into this imminent definition process where it means immediate, on the spot, the axe is falling, I have to act to save the child. We've struggled with that. That's why this slide's here, is because I have a briefing on it. Yeah, this is just sort of more information on imminent. And this is sort of one thing that you'll see frequently. It ties in with this idea about how speculative injuries are not enough. It's less than. So likelihood or bare possibility of an injury is not sufficient to create imminent peril. Again, going back to Mabe, that's sort of the classic example of how, there's danger, a serious danger, but it's not imminent, so we have to get a warrant. And the Ninth Circuit, I think we have a slide in here on it, in Rogers versus County of San Joaquin, they went a step further and said it was in terms of a neglect case. And what they said is, look, if there's a problem that with, the application of reasonable services, training, that sort of thing, could be corrected within a reasonable amount of time, then it's not imminent. So, that goes a step further, that it sort of ties in with the government's affirmative obligation to look for lesser intrusive alternative means of protecting the child, which would be the application or provision of services, right? Okay, what is not imminent danger? This is sort of cool because we can define by the case law what is not imminent danger. There's a lot of argument. Every case you file, you're gonna have argument with these guys over the issue of exigency and what's imminent, what's not. Well, the courts have told us what's not. That's kind of cool. So 2-hour delay necessary to obtain a warrant wouldn't result in significant worsening of the child's physical condition. That's not exigent, right? 2-hour delay, the kid's not gonna get worse in 2 hours, you gotta get a warrant. And I'll tell you this, RC, back then, it probably, if we'd have tried it, I wish we'd have tried it actually, because if we'd have tried it, we probably would have done a little bit better. But this got blown out on a demur, went up to Court of Appeal, ended up, great decision, came out, did a lot of things we've already talked about. We ended up settling it on remand for, I think it was like 500 grand, and went into an annuity for the kids, and that was cool. They're gonna have a college fund. But this was County of LA, Kenneth Freeman was the trial judge, and God, who was it? Averbuck and Geisler were the defense attorneys on it, contract defense attorneys. And what's happened since RC is they've started doing a tremendous amount of warrant training. All those things that we were arguing about in front of the Court of Appeal have sort of migrated their way into PowerPoints that the county council presents to their social workers on a regular and updated basis. So in LA, you should stop seeing so many unwarranted seizures. They've actually worked really hard to get that in line. Same with Orange County. Orange County's done really well. Oh, this is sort of another interesting one, came out of RC, is, I don't know if you guys have seen this, but if there's a past injury to a child, social services often will come in and say, oh, dad's a danger because, a month ago, 2 months ago, whatever, he broke the kid's arm, or the kid's arm was broken in his care, so he must be a danger now for some other thing towards maybe another child even. RC says, no, just because the kid's been injured, absent a showing that, dad actually did it, you don't get to take the kid based on the fact of a past injury. What this was a shaken baby situation. Child is at daycare, it's fine in the morning, the parents dropped him off, gets life-flighted out, ends up in children's hospital, social services gets involved, and 3 days after he was life-flighted out, Dr. Imagawa came and says, oh, retinal hemorrhage, shaken baby, don't know who did it, but he's in parents' care and daycare. So remember, we have to make an individualized assessment when we're looking at exigency. We have to look at each parent as to each child and say, is there a basis to remove this child from this parent? If no, then we have to leave with that parent at a minimum. Look at the other parent, is there a basis with respect to this parent and this child? And if there's more children, you have to go through the same analysis, individualized with each parent, each child. You pull out from Wallace versus Spencer. They didn't do that in RC. What they did is they just came in and said, oh crap, shaking baby, take everybody's kids from everybody. They even took the daycare providers, older kids. And we didn't represent her, we sued her, but she could have had a good claim and somebody picked it up and pursued it, it would have been worth something. Because they just can't do it. You can't, cast this dragnet and just sweep everybody in. This is Rogers, we talked a little bit about that again, what is not imminent danger. And I got it close to right. It's if the parent's conduct is not modified in a reasonable period of time, it could lead to long-term harm, does not present an imminent risk. Remember, we're looking at the time element. Malnutrition, one of the things that we were addressing in the case up in LA last year, actually it wasn't last year, I think it was 2016. They started to lose track of time. But one of the issues we're addressing there is that the allegation that the social workers made was that mom intentionally and willfully failed and refused to feed her baby, causing it to fail to thrive. That was the allegation. So again, we know that if there's a condition that a few hours isn't going to cause it to be any worse, we can't take the kid without a warrant. But that's exactly what they did here. They took the child without a warrant at a team decision-making meeting, and then went through the process, lied about mom, all that stuff. She lost the kid. But the point is that malnutrition, failure to thrive, which are big bugaboos for the social workers. I see a lot of these cases. It's not a basis to take a kid without a court order, yet they do it all the time. If you see a case like that, it's a good case. Yeah.
How do you treat substance abuse and the potential for a parent to use or get high in between in this period of time?
Well, just sitting up here thinking about it, if there's evidence to show that this parent is an addict and is going to get high every single day, 3 times a day on the hour, I would say there's no speculation involved there. You pretty much know it's going to happen. I would still get a court order if I were the social worker, and that would be a basis to get a court order. If they can go into court and say, hey, look, judge, historically, this is what this parent's done. At 9 a.m. after they drop the kids off, they get high. At noon for lunch, they get high. At 3, they get high. The judge is going to give you an order. Even if you have, a less regular schedule than that, if you can establish, or the social worker can establish a history of drug abuse that impacts the care of the child, right? Remember, it's got to have some impact on the kid. Just using drugs alone is not enough. The judge is probably going to give him an order. So if the judge would probably give him an order, and there's no evidence to suggest that this child's going to be injured in the next 2 or 3 hours, you got to get the order. You can't just take the kid. So that would be how I would answer that one. Yeah?
Sean, what if there's some evidence of threat of worried about the parent fleeing with the child while you're gone getting your warrant?
They want to throw that out there, and I know under the California statute, I think it's either 305 or 306, I don't remember which one, that flight risk is a basis to remove without a warrant. You can look through the federal cases, I've looked for it, and remember, federal law preempts state law. To the extent there's a conflict, federal law trumps whatever the state's doing. So we typically, even in Arizona, we don't really pay attention to what the state law is because it's preempted anyway. There is no provision in any case I've ever found in the Ninth Circuit that says flight risk is an issue. The proper thing for a worker to do if they think there's going to be a flight risk in the 2 hours it takes to get a warrant is either stay there with the parent while you're making your telephone application, which you can do, or call in for police assistance, have them stay with the parent while you go personally make your application. If we're looking at a 2-hour period, there's really not a lot of circumstances, at least in my view. Remember, I have a very biased view. I'm totally plaintiff-centric. I do zero defense work on these things. And I would never do defense work on these things, just philosophically. There's really very, very rare circumstances where you have the kind of emergency that they're talking about in these cases. It really is. The axe is falling. I got to do something to save this kid. And if it's not that kind of circumstance, it's not exigent. So that's my view. I mean, talk to the defense bar. They, I'm sure, have a different view. So failure to thrive, we see those. I'm sure you guys see them. Really cool case, Baker versus County of Los Angeles. It's a district court case. It's one of Bob Powell's cases. Failure to thrive does not give rise to an exigency. That's just the bottom line. Also, medical evidence. We see this frequently. I don't know how frequently you guys see it, but you'll see these social workers coming in, injecting their opinions into the records about, you know, how they think the kid needs medical care or isn't getting medical care, or, you know, the parents not following up with doctors that are needed, that sort of thing. That's not evidence to support a finding of exigency. Only a doctor can make the call. And if they don't consult with a doctor or have a statement from a doctor, something from a medical professional saying, yeah, there's an issue here, they can't take the kid. They can rely on what doctors tell them. That's why when I have the opportunity, I really go after these so-called child abuse pediatric experts, you know, the Wongs, the McGowas, the Sheridans, because the worker's entitled to rely on what these so-called experts say, their medical opinions. And invariably, these pediatric child abuse specialists will say, oh yeah, this is, you know, caused non-accidental trauma or whatever. And they'll give sometimes their opinion about a perp or a mechanism of injury. Then the social worker is entitled to rely on that, whether it's credible or not, and avoid liability. So whenever I can, I look to really hammer the doctors, because they have at least in my view, they have a completely independent responsibility to be honest in their assessments, regardless of what they're being paid or what their contractual duties are. And the things they say and do have a tremendous negative impact, or have the potential for a tremendous negative impact on hundreds and hundreds of kids. And they need to be held accountable, so we're working hard to do that. Whenever we have a chance to target a doctor, we do. Haven't won one on those yet, by the way. But that doesn't, that doesn't mean that you shouldn't try. That's how the law gets changed. That's how this whole area of law has evolved. Is you lose and you try again. You retool, figure out what you did wrong, and try again, and try again, and try again until you get it right. And then, things start to work. Oh yeah, emotional harm. That's like a 300C allegation, right? Is emotional abuse absolutely not a basis to remove a kid without a warrant. You gotta go to court, you gotta get the warrants. These people that are claiming, parental alienation, mom's coaching the kid to do and say these horrible things, it's emotional abuse, grab the kid. That's a good case, you're gonna make money on it. Because Ninth Circuit, you can't do it, not without a court order. And it's unlikely. Well, I don't know, because there was that comment earlier that I did not make about the judges potentially being a rubber stamp on these dependency orders and the warrant applications. I don't know whether there's merit to that or not. I wouldn't publicly admit it if I thought there were. But I was going to say that I don't think a judge necessarily would issue a warrant or detain a child based purely on emotional abuse, but in today's climate and with today's circumstances, what we see in the cases, something like that might actually issue. Things that undermine claims of imminent danger. Again, we were talking about, for example, the need for immediate medical care. See that frequently. Say, mom wasn't taking the kid to the doctor. Okay, social worker seizes the kid, takes the kid to some foster placement, doesn't go to the doctor either. That is good evidence, very solid evidence of a lack of exigency. If the kid's really in immediate need, you call the ambulance, you cart them off to the hospital, you get them their treatment. If you don't do that as a social worker, you've got a warrantless seizure claim on your hands, and this sort of thing here is worth money. That's a big deal. Government agents' prior willingness to leave a child in the parent's custody. Again, it's evidence that would weigh in or against the finding of imminent danger. And that's from RC, but where that concept first came up was in Rogers versus County of San Joaquin. The social worker went out, investigated, said, there might be something here, gee whiz, I don't know, left, came back a few days later and seized the kids. That delay in action on the part of the social worker, again, goes to undermine the claim of exigency. If there was really an emergency, if the kids were really that bad, grab them right now, get them out of there, right? So that's one of the things that you'll actually argue to a jury, depending on what venue you're in. If you're federal court, you'd probably, if you have that kind of circumstance, you can probably get a partial summary judgment in your favor on liability. State court, it's gonna be tough because you just don't have the vehicle. Okay. Reasonable avenues of investigation. Okay. They can't seize a kid without first investigating, right? That's kind of a no-brainer. But what does that mean? What do they need to do? They get an allegation, they need to actually go out and talk to witnesses. If there's witnesses identified that may corroborate or undermine the allegations, they need to talk to those people. There's a little bit of tension here because as I think about it, you would think they have to talk to the victim, right? But then there's this tension with Green and Calabretta and the Ninth Circuit saying you can't really do an investigatory interview of a child, certainly not a non-victim child, without a court order or consent. And typically when you have the two parents, they're not both, alleged wrongdoers. Usually it's one or the other, and the other one's just failure to protect. So there's a little bit of tension there about what constitutes a reasonable avenue of investigation. But the law is clear, you have to do some investigation. You can't just take the hotline referral, run out, talk to the school teacher, and grab the kid. You've got to go further than that. After acquired evidence is actually pretty cool. We see this all the time when we file these warrantless seizure cases, is the government, now they really will investigate. They're getting sued for millions of dollars, and holy crap, what are we gonna do? They'll go out, do the investigation that the social worker should have done before the seizure, and they'll start turning up stuff that, maybe did justify it. That's a problem, because remember, back to that memorized statement that we all want to learn, it's unlawful to remove a child from the custody of its parents unless at the time of the seizure, at the time you remove the child, you're in possession of specific articulable evidence, blah, blah, blah. So that's where this ties in. At the time you remove the child, the entire body of evidence that you have at that moment is all the social worker gets to rely on in defense against your claim of conduct without a warrant. So they can't come in later, drum up a bunch of stuff. And even in the context of the juvenile dependency case, they may not have had sufficient evidence at the time they removed the kid in that case. Probably there the judge is going to let them go investigate, drum up all sorts of other dirt and keep the kid. But that does not impact in any way your ability to litigate the warrantless seizure in the civil rights context, because you take a snapshot in time. Whatever evidence they had at that point in time, the point of seizure, is what they're stuck with. All this later stuff, drug use, prostitute, whatever it is, if they didn't know about it when they seize that kid, they don't get to rely on it to show exigency. This is sort of the same thing, just a little bit different phraseology. Merely in the hope that further investigation will turn up some dirt. Duty to investigate. Talked about this a little bit earlier when we were talking about pattern deposition questions, where you want to lay out with the social workers their understanding of what their duties and obligations are. And they have a duty to investigate and drum up information, exculpatory information is what this is referencing. Now, we talked about this a little bit earlier. It comes from Baker and Wallace. That's the obligation when they're looking at potentially seizing a child, their obligation to assess each parent as to each child on an individualized basis. They can't just assess one and take all. They have to look at each option for, action. Okay, deception in the presentation of evidence violates the 14th Amendment. We've talked about that a little bit. Where we see this happening, again, is warrant applications or affidavits, petitions, although we haven't made a false statement and petition stick yet. We're working, that's one of those things where you fail and try again, but we're working on it. Detention reports, juris dispo reports, status review reports, addendum reports, anything and everything that the agency or worker is going to file with the juvenile court to try to influence the juvenile court's decision-making process is subject to a judicial deception claim. Yes?
Yes, Ron, is, to you, is the theory of judicial deception now kind of replacing what used to be warrantless removals, in as much as warrantless removals are more or less a thing of the past?
To some, in California, I would agree with you. I'd say, yeah, they're pretty, at least in Southern California, let me hedge that a little bit. In the counties where it's been sort of hotly litigated, they are changing. And they are getting warrants, at least more frequently. We still see situations where they didn't get a warrant and they should have gotten a warrant, or they'll take a kid and then say, oh God, I screwed up, and they'll get a warrant 2 or 3 days later. So there's still a little bit of implementation problems that's going on, but you don't see the frequency. So to answer your question, I'd say, yeah, I was talking earlier about how, there's like a rat in a maze trying to find the cheese, right?
Yeah.
And we found the cheese on the warrant stuff, and we ate, a hearty meal. And then they moved the cheese, right? And now it's not that they're necessarily better about the way they act and the way they treat their clients and their lack of respect for our rights. It's a change in mechanism. So, yeah, they moved the cheese, judicial deception is where it's at.
Thank you.
Yeah.
For the third-party statements, like what if the BS statement is made by the anonymous reporting party? Like I have a case where the grandparent, like the quote was that they're selling meth out of their garage. They don't even have a garage. So, like how do you challenge it if the person's anonymous?
Well, in the juvenile dependency court, I'm the wrong guy to ask that. In the context of a later civil rights claim, first of all, if, and I don't think I addressed anonymous tips in here, maybe I should have, I'll make a note on that. You go back to the basic rules on warrants and warrant requirements, and an anonymous tip standing alone is not going to be sufficient. So if they have an anonymous tip that was then investigated and corroborated by third-party witnesses who are credible, and remember, credibility is always an issue when we're looking at warrant applications or actually anything in the dependency court. We'll get to a slide on that, is credibility can also be, or lack of credibility of a witness, can also be material exculpatory evidence that has to be disclosed. So these sort of it starts to get sort of complex because all these things start to interplay with each other when you're looking at suppression of exculpatory evidence. But, I forgot your question with all that. Can you ask me again?
So if you can't depose someone and be like, did they even ever talk to you? Is this true? Because they're anonymous. How do you challenge the third-party statements?
The burden in the civil rights context, the burden's going to be on the social worker to prove that up. All right, I'm coming in, all my witnesses say you're a liar, you say you have an anonymous tip, okay, fine, great. Who is it? Identify them, we get to depose them. The confidentiality, mandated reporter, foster placement, all these things that in juvie court or state court proceedings, you would not be able to get access to because of confidentiality rules and all that. Federal court, remember, under Felder v. Casey, and Martinez too, Martinez versus Los Angeles, the same basic rule. Federal law preempts. As a federal civil rights plaintiff, you have a right to all the discovery you need to prove up your case. And that trumps the confidentiality of these so-called anonymous tipsters or whatever. So when you're in federal court, you're gonna get all that information. You're gonna get to depose that person if they exist. You're gonna get them. State court, that's another venue consideration. If you have a situation where you don't know who the players were, consider whether or not you might be better off in federal court, because the state court is going to defer to the juvie court, and in your 827 process, the juvie court may or may not be convinced to release the identity of these people. And even if they are a material witness, that's one thing we're fighting. Who was talking to me about it down in San Diego on the Gordon case? We've got like 14,827 petitions to try and get unredacted information so we know who the material witnesses were to the repeated long-term rape of this kid that was in care. And they're pushing back, they're fighting over something. It would seem obvious they should give that, but they're fighting it. So think about your venue, if you have anonymous tipsters or people who you don't already know who were the mandated reporter or, you know, interacted on a confidential basis with social services. I think you had a question too.
I did have just a quick question, and I guess it's sort of, I know we're getting close to the end of time, but,
Are we?
uh,
I've got at least another hour if you guys are willing to stay.
but I do have a question about, you know, social workers, you know, their job description and their obligations are very driven by state regulations, and it's a very statutory-driven process. And setting aside the warrant, but I'm looking more at cases that are already being serviced in the system. You know, how does that factor in to the fashioning of a complaint if there are consistent violations of regulations on, you know, maybe it's notice requirements or services that are to be provided or home visits or, you know, and there's no.
It's not happening.
It's just not happening. Let's just say theoretically that you can absolutely prove, you know, multiple and egregious misconduct.
Right. No, that's not uncommon. We see that all the time. And this is one area where the state law claims may come into play, because you know what you're talking about are mandatory statutory duties, right?
Correct.
And they're not adhering to those mandatory statutory duties. If the child's sustaining some sort of physical injury, that's the easiest one, is physical injury like molest or abuse in the foster placement, inadequate care in foster placement, then you can address that in state law. Now under Tomas, remember the child has a 14th Amendment protected liberty interest in safety and security and in the provision of minimally adequate care. So if these failures to give proper notice, failures to go out and investigate at the foster home are resulting in this child either suffering a loss of services, like for instance if they need medical services or even they're not being adequately fed, that can potentially give rise to a Tomas claim. It's minimal adequate care. Is this child getting minimal adequate care? And are they not getting it because this idiot worker is not doing their job? So that's the question. And my feeling, I haven't done one of those cases yet, and maybe Jack, you can answer something on the state law
Well,
side.
I think the state law counterpart would be the special relationship, that there are cases that hold that there's a special relationship once the child's a dependent.
Yeah.
And then that carries with it an affirmative duty to protect the health and safety that would go beyond the regulations. So that's what I think would be taking you beyond the regulation mandatory duty, would be the special relationship and then the affirmative duty to protect the health and safety.
So that goes for potential litigation on behalf of the child, but what about the parent?
The parent, we haven't done one of these yet, like the Tomas claim where you have a child that's being repeatedly raped in a foster placement. But if we go back and we think about it for a minute, and we think about the rights of the parents and the children as being corollary and coextensive, like that umbilical cord, a violation of the child's rights, unless the parent's rights have been terminated by court orders. Remember, just because the kid's in care, doesn't mean the parent doesn't have rights and the child doesn't have rights to their parent until a court order terminates those rights, right?
Right.
So if we know that, and that their rights are coextensive and they're connected, a violation of the child's rights, regardless of the mechanism of the violation, should be a violation of the parent's rights as well. Because the parent is entitled to have their child taken care of. You know, once the government assumes responsibility, the child has a right, and in my view anyway, the parent has a right to have that child taken care of. And we're going to be trying that exact case.
And what's
The situation where we have child that's in Polinsky Children's Center down in San Diego, she's got some psych issues, repeatedly runs away, ends up getting raped. Yeah. The Children's Center sits on it, doesn't disclose it, just all this craziness with the parents. Parents don't even know until the daughter convinces a cop at the hospital to call her mom. And so the issue there is, what rights does the parent have? Obviously, the child's got a clean claim. The issue is what rights the parents have.
The issue for me isn't so much the distinction between the 4th and 14th Amendment, but rather the stage of the dependency proceeding. As Pam was saying, the court seems to be, at least my experience in California, particularly all of Southern California, seems that once the court asserts jurisdiction, or is known as the case has gone to disposition, a dispositional case plan on that child has been ordered by the court, does that case plan in fact act as a parental limitation, as an order limiting a
Your civil rights
parent's right
claim?
to know about what's happening to the kid?
Well, I think it's going to depend on the extent to which the parent's rights are limited by court order. Because remember, until the court orders it.
Right, but that sort of begs the question. The question that I had is, to what extent does the court going to disposition limit a parent's right to know what's happening with their kid?
Well, once their rights are terminated, that's the end of it.
No.
Yeah.
We're at post-disposition. We're in disposition. We still got the 2-1E, the 2-2, and all sorts.
Yeah, but see, after jurisdiction, and I could be wrong, I don't practice independency, but it's my understanding that after the jurisdictional finding, we're looking at either family maintenance, reunification, or some other placement.
Yes.
If we're in reunification, then the parents still have rights. Yeah.
Well, unless the disposition order says something along the lines of, and the parents are not to know anything about what has happened to this
Right.
child,
Right.
then their rights are not limited. And I think there's an awful lot of abuse that goes on with social workers who think
That's what I'm saying.
once
See,
the
and
child
that-
is placed in their
Jan,
custody.
we're saying the same
Yeah,
thing.
so-
And that's going
That's
to be a
different-
violation.
Yeah, that's a violation.
Yeah, that's going to be a violation. 'Cause remember,
No question.
Well, then this goes into your traditional deception doctrine, right?
Yeah.
Right? That's what I was
maybe
trying
it
to get
depends.
to.
Yeah. Sean, I hate to do this, but can you jump to Monell? Because
Yes.
we're already way over time, and I
I
think
know.
it's really important for people to understand Monell.
You guys are lucky. I had 147 pages to this.
I could be here all day.
Can we get that?
Yeah, I can email it to you. Just let me know. Send me an email. Where is it? That's.
Page 27?
Yeah, I didn't number these pages either. I guess I'll do that next time.
No, you did.
Oh, did I?
Yeah.
Oh, no, they did.
No,
They
he
did.
doesn't have this. No, he doesn't have this.
Oh,
He
this
has
is
to
big.
do this.
Manila is on 27.
Hold on, I'll get there.
No, Sean, it starts off your duty to investigate and correct factual error.
Okay, got it. All right. We'll do Monell, and like I said, I'm here as long as you guys have the room and want to stay. The idea is to get you as much information as I can, so I'm not time limited. If you are, that's fine, just, split it as you need
We'll
to.
have to catch a plane.
Oh, okay. Okay, so on Monell, it's pretty simple, really. We talked about it already. There is no respondeat superior liability to the county for the constitutional misconduct of its social workers. So what the Supreme Court has done, and it's sort of interesting that Monell, the case itself, was against a social services agency. It was in a different context, though. It was, as I recall, employment or employment dispute, class action, ended up getting certified. But the idea that came from that is that 42 U.S.C. section 1983 and the concomitant fee shifting statute 1988 apply with equal force to municipalities as they do to individuals. To get liability there, though, since we know no respondeat superior liability, you have to show that the municipality, county, city government, whoever it is, themselves or itself caused the violation of the constitutional right. So that gets a little tricky because, the person that's really causing the constitutional violation is a social worker that is out there grabbing the kid, right? They're the one doing it. But if you can show that the social worker is grabbing that kid without a warrant because of a failure of constitutionally inadequate training, enforcement, lack of discipline, lack of a policy in the face of a known need for a policy, Because remember, for Monell, we have to show a deliberate indifference. If we're looking at a failure of training or a failure of policy, you have to show that the government knew or should have known that the training was inadequate, or that they needed a policy to address potential violations and didn't promulgate one. Or if you have a policy that on its face is violative or would lead to violations, that's a little bit different standard. You don't have to do the deliberate indifference showing. But you would have to show, and I'm not talking about the facial violative policy, we're just talking about the different ways you would prove, I guess, circumstantial claims. So you have to show somehow that the government knew or should have known that this problem existed and then failed to address it. And that essentially is where we get the Monell liability. And let's just zip through to that because I have slides on this. Oop. Okay. So only two elements, really simple. Is that fault, that is that the action or inaction of the government, through policy, custom, training, that sort of thing, caused a violation of the constitutional right? So it's fault and causation. To get there, you always have to prove that some live person, a body, violated a right. So you're always going to have to, in our circumstance, it's social workers. You don't necessarily have to sue the social worker, but the social worker's violative conduct is the vehicle that gets, it's the dagger that gets you in the Monell little heart circle. So you need that. And, like I said, there's a lot of different flavors of Monell. Second thing you have to prove, this is causation. When they're talking about causation, they're not really talking about it in the sense we think of it in the civil arena, where we're talking about substantial factor, but for analysis, that sort of thing. What the standard is, at least in the Ninth Circuit, and in state court, you may be able to get the judge to just give a substantial factor instruction, which is really cool because that's a lot easier to prove. But in federal court, you're going to get saddled with this concept of moving force. You have to be able to show that the policy, lack of policy training, custom practice, whatever it is, was the moving force that caused the worker to do whatever it is they did. I have a problem with that just because moving force, what the hell does that really mean? I mean, what is a moving force? I have a problem with it, and I kind of assume if I don't really get it, is a juror really going to get it? So, and I've had this discussion with the federal trial courts, and everybody seems to understand, yeah, it's an issue, but there's no change there. You're going to get saddled with moving force. And now we don't need, this is the cool thing, and you'll see this all the time in the government's answers and their motions to challenge your pleadings, is they'll come out and they say, oh, well, you haven't shown that we have a formal policy that's violative of your rights, or a formal policy that's causing these workers to go out and do these bad things. And that doesn't matter. It's actually kind of asinine when I hear these arguments. I hate to use that word, but that's it. Because the law is really clear on this. We don't have to have a formal written policy adopted by the County Board of Supervisors that's violative or causing a violation of constitutional rights in the state of Monell. There's this whole panoply of things that are not in writing and don't need to be in writing that also support the Monell claim. And custom practice is one of them. Christie Iopa is a great case, and we rely on it frequently. Long-standing custom practice. In fact, the law is really cool on this. The county can have a policy, and LA and Orange County do this now. They have a policy that says, get warrants under this long list of circumstances. But the practice is to not really follow the policy, they just do something else. They won't get warrants under some of those circumstances, they'll just take the kids. So even though you have the best policy in the world in writing, if the practice is not to follow it, that's still a Monell violation. So you can still nail them on that. And like I said earlier, Monell is where the pot of gold is on these cases. if you can get in and either inferentially or circumstantially show that whatever your violative conduct is by the worker over here is known about by the county, or it's the standard custom and practice for them to do it that way, you're gonna get a Monell claim. It's gonna go to the jury gets to decide it. Depending on the facts of your case, the jury's gonna hammer the hell out of the government for not, keeping its workers in line and doing things the correct way. That jurors get pissed off about, government going amok. That's another thing is, and this was a cool case, again, up in the Bay Area. This was, I remember the guy, I don't remember his name. It was a good case, though. It was a jury instruction case. And a lot of the different flavors of Monell that we're going to be talking about, he tried to fashion instructions. And again, if you look at the model instructions, Ninth Circuit, they don't have a lot of guidance on these types of claims. So the guy tried to fashion, special instructions based on the law that relates to these various types of Monell violations. And the trial court rejected it, said, no, can't do it. Wrote its own instruction. Appealed. Ninth Circuit came back and said, no, that's wrong. There's multiple different avenues that you can follow to establish a Monell claim. And the plaintiff should have been permitted, as I think it was each and every one of his proposed instructions addressed a different avenue, different flavor. And the Ninth Circuit said, yeah, you get to give them all. So that's a good place. Hunter's a good place for you to go look for instructions on Monell, and they cover there a lot of the different avenues of recovery that you can follow. But anyway, the point of this slide, it's obvious. Policymakers don't even necessarily need to know about the practice. So that'd be like the Board of Supervisors or whoever they've delegated the policymaking duty to. Usually it's going to be the director. He doesn't even necessarily need to know that these bad practices or bad customs are in place at the field level in order for those, to get an avenue or a vehicle of recovery under Monell. Okay, the next slide, that gives you probably can't even read that, that's really small print. You have your slides in front of you. But you can see there's a lot of different ways you can get there. You can show a pattern of inadequate training. That's our favorite. That seems to work out real well. It's easy to prove, because what you do, I'm going to talk to you about how we depose these social workers. You get them in a room on a video camera, say you've been trained. Yeah. You've been there 20 years. Yeah. You get recurrent training. Yeah. You get training on the Fourth Amendment. Yeah. Okay, what is it? Huh? Oh, I don't even, I have one on YouTube, you can look at it. It's a lady named Kimberly Rogers up in LA. She goes, I don't even know about the Fourth Amendment. You tell me what that is and I might be able to help you. And you whip out their training packet and you say, is this one right here? So on a pattern of inadequate training, you can prove it up within the context of a single case by deposing multiple workers involved in your, anybody that has a fingerprint on your case. You just go through their training with them. They're not going to know it. They don't remember it. They don't take it seriously, and they certainly don't apply it. So you just get that stuff, and that's good stuff. If you now, what we've done is county by county, we keep a dossier on each county, each social worker. And we pass that around. I think I said earlier, there's like 8 or 10 guys in the state. All we do is sue social workers. We pass around our information. We keep a dossier on each worker, each county, on the various violations, and we all videotape depositions. So every now and then, I get kind of lucky, and I get a social worker that's a repeat offender, and I've got a couple depots on her, Powell's got a couple depots on her, Cox has some depots on her, and it's great. Because you have it all right there, and they say different stuff every single time, but the thing they're always consistent about is their inability to tell you what they were trained. So you can prove up a pattern or practice or a pattern of inadequate training over a course of cases. That's another way you can get there. Actual knowledge, that's kind of a no-brainer. That's like the facially violative policy. If a policy is violative on its face, if the Board of Supervisors or the person they've delegated to, usually the director, knows of the practice, knows of the pattern, doesn't do anything about it, then the municipality is directly liable. You can get them for that. Ratification, that's somewhat obvious. Now, this is an interesting one. In Fogarty Hardwick, this came into play both on the summary judgment motions and at trial and on appeal. And it's number 4, it's sufficiently notorious misconduct so that official policymakers know or should know of the risk to people's federal rights. Back in the years leading up to like 2007, there was a lot of media coverage over social worker misconduct. There were a lot of allegations in the media, public knowledge. Social workers allegedly are lying in court reports, causing parents to lose their kids or, various other things. So it was all over the place. And we were able at trial to bring that information in front of the jury and say, hey, look, management knows about it. How can they not know about it? They're getting letters from the mayor, the media is covering this. It's all over the place, but they're not doing anything to prevent their social workers or train their social workers to stop lying. So we were able to we got a unanimous verdict on the Monell claim on failure to train. We got that there. On appeal, this was really stupid. It was so stupid, it's funny. The county enlisted the County Association of County Council or whatever it is, some association these counties have, enlisted them to do an amicus brief on the appeal. In the amicus brief, they come up on behalf of all California counties, they do this nice little paragraph saying, oh, we represent everybody. Saying, allegations of social worker deception in juvenile court proceedings are ubiquitous.
Oh.
That was a really neat word. And I remember this oral argument. We're going through it, I said, wow, ubiquitous. I looked that up. Everything, everywhere. So how can they claim they didn't know? And when you read the opinion, that's what came out. It's not an isolated incident. They definitely know about it. They got to fix it. So number 4 is a good way. And one thing that we do now is when we have a new venue we're going into, we try to get media contacts. We try to get them to start, publishing articles, doing news coverage, things about our issue. 2 reasons there, because we want widespread public knowledge, right? That gets us number 4. But also you have to figure, there's probably one I'll edit out, but you have your veneer that's going to be deciding your case. And the more you can inject your theories into their daily programming, the better you're going to do at trial. So anytime we go into a new venue, we're trying really hard to get some coverage, get stuff pumped out in the media, get some public knowledge established for dual purpose. One is so you can show widespread public knowledge, and the other is to influence your jury. Final policy making authority. Gap in policy, this is another big one. This is what we hit on up in LA. Number 6, that's a gap in policy or training in the face of a known need. You see all the law there. But what happened up in LA, and this happens frequently because there's a lag time between creation of a policy, training on the policy, and fully implementing the policy. So what you end up with is a gap. And a gap in policy or training in the face of a known need is a Monell claim if it caused the injury. And this is what happened up in LA, is they started working on a warrant policy after Judge Nash up in presiding ordered them to do it. And it was funny the way he did it. He wrote a memo to the county saying, hey, look, Wallace and May have been out for 10 years. I haven't seen a single warrant come across my desk. Get with it. County ignored that first letter. He wrote another letter, verbatim, same thing, saying, okay, now it's 2 years later. I still don't see any warrants. And what happened then is they actually started working on a policy, opened up a courtroom, made it mandatory. But by then, our client had already lost her kid without a warrant. So the policy wasn't in place. They had no training on it. They got it. The first training they did in advance of releasing the policy, December 2009, but they seized our client's kid in November 2009. So we had a gap, right? It was that gap, unanimous jury verdict on it. That was the $3.1 million gap in policy Monell. They never would have hammered the individuals like that. The money came out of the Monell claim. Okay, routine failure to follow policy. I sort of talked about that a little bit. When you guys look at Hunter, it's a wealth of information. It really does cover the whole gamut of Monell. I suppose not all of them, but many, many of the different ways you can establish Monell liability. And we talked about this, the greatest policy in the world doesn't do jack for you if nobody follows it. So a routine failure to follow established policy itself can lead to Monell liability. Policy, ways to prove it. How do you prove it? We talked a little bit about that. Policy custom, it can be inferred if after constitutional violations occurred, officials took no steps to reprimand, discipline, should say also, or investigate. And the way that you do this, we do this in every single case, is you get a person most knowledgeable from the county, and you say, okay, you're being sued here. Yeah. You know why you're being sued here? Yeah. Have you done any investigation to figure out how to fix this, or whether it happened, or how it happened? Well, no, we leave that to our attorneys. Okay, well, was this person reprimanded? No. Anything, a letter, further training, anything? No. And you accumulate those, right? And then you go to the next person. Have you ever heard of anybody being reprimanded in any way for doing this kind of thing, whatever it is that you're suing them for? And you go, through it with the person's most knowledgeable, the individual defendants, everybody involved, the supervisors, the HR person, same line, pattern questions. Everybody's all no. You get to put that in front of the jury, you get this instruction, say, hey, look, they're not investigating, they're not reprimanding, they're not disciplining, they aren't doing anything. Right? Pattern practice. Custom. Failure to properly investigate constitutional violations. That's another thing. The social services agency, there's a mechanism by which people can make complaints. Those complaints should be investigated. If there's actual findings made or it's discovered that the workers did something inappropriate, there should be some discipline, something's supposed to happen. There's a lady named Lynn Condon up in LA. She's the HR lady. She signs off on all of the disciplinary actions by the agency that include all the way down to just letters of reprimand, all the way up to termination. She knows about them, she signs off on all of them. In every county, there will be somebody like her. You want to depose that person because they know. They're the ones that sign off on it. They're the ones that approve the discipline, no matter what level of discipline it is. They will know who's been disciplined for what and how many times and what the basis was, what the facts were. You sit them down in the depot, you ask them about it. Invariably, they will say, no, I didn't even know that kind of thing happens here. Why? Well, because you don't investigate. They take those complaints from parents, they take our complaints that we serve on them, they go directly in some file that nobody sees again. Sorry?
They go in the round file.
Yeah, the round file. I didn't want to say they throw them in the garbage, because they may not. I mean, they might put them somewhere else. Give them the benefit of the doubt, but what does happen for sure, at least until recently, and they may do this now up in LA because they got really heavily tagged, they don't investigate these things. Even when they're in litigation, they leave it to their civil attorneys, and once that's done, they're like silos. There's no communication between county management and their civil attorneys. So even if there was a problem that the civil attorney, defense attorney uncovered and is wanting to address in the litigation, it will not typically get addressed in terms of policy and training at the county unless there's a big verdict. And then they kind of pay attention. Okay, we've already covered this. This is a gap in policy. Again, it's Thomas versus Cook County. You can kind of look at that. Another one, and this sort of ties in with that number 4 on the first sheet, the extent and openness of workers' constitutional violations supports an inference that the managerial level, that's the supervisors on up, should have known of the violations and should have known of the need to stop it, fix it, right? And remember, it's always, whenever you're looking at Monell, you're looking at the conduct of the line workers or the people that have personal fingerprints on the case, the supervisor maybe. You're looking at their conduct, but only in the sense that you have to prove they did something wrong in order to get to the Monell issue, right? So here where it's talking about managerial level employees, we're really talking about above supervisors, people that have policy-making authority on the part of the county. So it'd be like the director, the program manager, people like that. And if the nature and extent of the misconduct is widespread, and you can show it, everybody's doing it, then there's going to be a presumption that the person in charge at top, on the top of the chain, knew or should have known and should have fixed it.
Sean, just briefly,
Yeah.
can you talk about if the county's position when you're going after them in this way is to hold say the worker went rogue, they went off they were outside of policy, is that your way of getting at it because there was no discipline taken, so you're deposing the person who, if in fact that's true, they should have been disciplined?
They try that. And this is the problem with that. And if you think about it for a second, it makes sense. I'm the county. I know I'm the deep pocket here. Let's put it all on the worker, right? Put it all on the worker. We're good. Okay, well, where's your training? Let's see your training. Where's your policy? Let's actually see it. Oh, I don't want the one you got now. I want the one that was in effect 4 years ago when you were screwing with this family. And maybe they can turn it up. Maybe they can't. If they can't, our argument is, and we've successfully made this argument to a jury, look, if they had the policy, you'd see it. You don't see it. That means they didn't have it. And that's why this happened. So, yeah, the inclination is to push it off on the worker, but it's hard to do because you're going to go after policies, you're going to look for training, you're looking through their records and they're historical. They can't change history.
Yeah, and it also seems like you addressed that earlier, by you're deposing multiple workers, so you're gonna see maybe a threat where it's not just one person to show it was just one person screwing
Right.
up. And two, that no disciplinary actions were taken, and so there's
Right.
wrong oversight.
That's right. That's
It seems
exactly
like
right.
you've addressed that.
Well, one thing that you see, and we saw this up in LA, it was kind of crazy. It was clear that the workers had been prepped to say, or at least the first depot, the worker had been prepped to say, oh yeah, I had all this training. And it was great because then I got to read in my jury instructions through her. That was wonderful. You get to her supervisor, start asking the same questions, and she says, well, yeah, I got that training, but we didn't get it until 2011. And so there's like this disconnect. And it was kind of cool because you play that to the jury and say, okay, well, she's, and every question I follow up, and you knew that in 2009, November, when you took this kid. She said, yeah. And you knew that too, yeah. And you did it anyway, yeah. Then you get the supervisor saying, well, you know, that training, I didn't have it until 2011. You get the PMK saying, we didn't even do it until late 2011. And you're playing all this stuff to the jury, and they're saying, okay, somebody's lying. Somebody's lying to me. And the minute that you expose the lie, the issue isn't really any longer whether or not you're going to win the case. It's you know how much they're going to give you. And this is another thing, and we do this in request for admissions. In every single case, we'll send out a request for admissions right at the beginning of the case, saying admit that the social worker at all times in their handling of the juvenile dependency matter was acting within the course and scope of their duties as an employee of whatever county. They'll always admit that. That's great. Then we'll also send them an admission that says, admit that all times in their handling of the case, this defendant's social worker was acting in conformance with your policies, in conformance with your customs, in conformance with your practices. Usually they will admit that because they're thinking, and this is crazy, I don't know why they would think this, but it happens every time. They're thinking, oh, you know, it's a policy claim. Our policies facially are okay. So we'll just admit that the worker was acting according to policy, custom, practice, and we should be fine. What they're not thinking about is what's going to happen at trial, right? We're not going to get up there and say, oh, these written policies, blah, 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 blah. No. What you're going to do is you're going to get in there and you're going to prove that these people lied. You're going to prove that these people suppressed exculpatory evidence. You're going to prove that these people took a kid out of spite, which is often the case in these cases. Mm-hmm. And then you're going to stand up in front of the jury and you're not going to read their policies that say, don't do this. You're going to stand up in front of the jury and you're going to read those requests for admissions. So, ladies and gentlemen, before we got here, we asked them a bunch of questions, and this is what they said. These workers that you've heard all this evidence about how they lied, they cheated, they suppressed. Act in accordance with policy. Here it is. They admit it. Look. Act in accordance with custom. Here it is. Look, that's their verification. Act in accordance with practice. That has worked every single time. And they still don't figure it out. So I'm going to edit that out. But, you know, you guys don't spread that around. Keep that as like your little secret.
How are you gonna edit out their culture? Because you just.
Well, no, I'm going to edit out my little trick. You know, I set little tricks and traps all over the
The
place.
problem they've got, in a sense, is that they're in a culture that supports and encourages this sort of behavior and these lies.
What you're going to do is you're going to use an expert. And what we use a lady, her name's Alandria Safer, and she is an industrial and organizational psychologist. And she will come in and testify about how these policies, training, implementation, enforcement or lack of enforcement, the silos between the different departments, how that all plays together to impact the culture, which encourages or permits, depending on how you present your case, these social workers to engage in this bad conduct. And so you're going to do some of that through direct testimony, some of that through your expert testimony. And the person we use for that is Alandria Safer. And then for the social worker side of it, we use Melinda Murphy. We've talked about this a little bit, so I'm going to sort of skip over it. Seems like everybody's kind of winding down on me here. You know, it's the deliberate indifference standard. And again, we're looking at, you know, where we have social worker misconduct in our instance. This applies to police too. So police misconduct, sheriffs, all the government agents applies equal force. But if there's evidence that the people that they regularly come in contact with in the course of their duties as a social worker, they're violating those people's rights and the government does not have something in place to deal with it, again, they're deliberately indifferent to the need. So they have to address it. That also leads to a no violation. Deliberate indifference, there we go. What does that mean? It's a conscious choice, and this isn't one of those slides that you can disregard. This is actually a federal law. Conscious choice to disregard the consequences of one's acts or omission. That's why when we're talking about training, you have to have that hook. You have to be able to show that the government knew or should have known that the lack of training was likely to lead to constitutional violations, or the lack of a policy was likely to lead to constitutional violations. So that's your deliberate indifference. The deliberate indifference standard does not apply to all flavors of Monell. So you have to look specifically at what your theory of liability is to figure out what level of consciousness you need to establish. This is how you would go about proving it. As we've talked again a little bit about this, the widespread public knowledge, the recurring violations, failure to adopt policy, implement rules. It's all the same sort of stuff we've already covered. What's not discussed on this slide but does arise in Chu versus Gates, it's sort of an interesting situation there. It was when they were using police dogs and they didn't give adequate training. They released a dog on a guy, just chewed the hell out of him, and he sued. And at that time, that's Chu versus Gates, right? at that time, the government didn't have any real concrete policies or training about how we should use these dogs in the field. So what the court said there is, okay, where we have a lack of policy and a lack of training on an issue where we know that we might need something, what we're going to do, because remember for Monell, we have to be able to show that top level management caused the problem or didn't deal with it, set the circumstance up. What we're going to do in the circumstance where there is no training, no policy, but there's reason to know that we might need it, like when we use deadly force or a dog, gun, that sort of thing, we're going to treat the line level agent, whether it be the cop or the social worker, we're going to treat them as the policymaker for Monell purposes. And if what they did is a violation, we're going to tag the municipality with it. So that's another place where this gap in policy, gap in training comes into play. You'll see this mostly on your summary judgment oppositions. Very rarely would I think this would get in front of a jury on this issue. But you're going to be able to argue, look, no policy, no training, or one or the other, but inadequate. Then we don't have to go and say, oh, the director caused this, or knew about it, or ratified it. It's the line worker that engaged in the violative conduct now becomes the policymaker for Monell purposes. So that's sort of a nuance that comes out of Chu versus Gates. I'll make a note on that because that actually should be here. Yeah, this is just black letter law. Again, how to prove it may be proved by showing county knew its failure to train, made it highly predictable that its workers would engage in conduct to deprive people of their rights. Where that comes into play again is the police shooting cases in the early, when was that? I think first the city of Canton and Harris. And what happened there, same sort of thing. It's predictable if you give a cop a gun that he's gonna shoot somebody, right? I mean, that's highly predictable. So we need to have some policies, we need to have some training so that they don't go out and shoot the wrong people or shoot people who shouldn't be shot. The same idea applies to social workers. You're going to vest them with power to take children. Where we see this mostly is in the context of unwarranted seizures or searches. They have the power to go and grab children or look at children and do these things with children. So it makes sense that if we're going to vest them with that power, they're going to use that power. So we have to train them. We have to constrain them through policy and, through the training, educate them about what those restraints are. Otherwise, when they're out in the field doing their thing, they are going to be the final policy and decision makers with respect to the conduct they're engaging in, and we're going to get hit with Monell liability. That's why on all these counties, Southern California counties, as we've been suing them, you've seen them start to change the way they do things in terms of getting warrants, interacting, maybe not so much with the court, but interacting with the parents. You've seen these restraints put on them, and they're starting to sort of follow them, because if they don't, then the line workers that are out there screwing up, the county's going to get saddled with the liability because they didn't do anything about it.
When they've done something like they've done in LA with Gabriel Fernandez's demise and the successful criminal prosecution of the parents, now the criminal prosecution of the social workers, they have this new oversight agency run by Judge Nash.
Yeah.
I would suggest the possibility that with all that, what you've really done is just made for more anxious social workers who overreach and do the same corner cutting that they have been doing, only you've got all this.
In the other direction.
Yeah, well,
Yeah.
they're in a panic, and understandably so. They don't want to be criminally charged, for example, so they're going to err on the side actually of over-detaining. They're going to cut more corners. They're going to violate.
I've heard that argument.
Yeah.
And this is what I think about that. It's not really a legal issue. It's philosophical, I suppose. But there's a mechanism in place, and it's been in place for, I don't know, when did we sign the Constitution? Like 89 or something like that? Whenever it was. It's been in place for at least a couple hundred years. And that's this warrant requirement. And we know for a fact that it does not take more than a couple hours to go to a judge, say, hey, look, I think this kid's in trouble. This is why. Give me an order. Let me go take this kid. So if the argument is, oh, I'm going to rush and take kids regardless of the circumstance because I don't want to be that Gabriel Fernandez worker. Fine. 2 hours out of your day, get a warrant. You think you have the goods? Get a warrant. It's not that big of a speed bump, really. And then on the other end, if you don't go out and get a warrant, you don't make that effort to grab the kid, maybe you have some culpability there. Because the tools are there. They've been there for 200 years. Use them, right?
Yeah, just speaking of warrants, now the question I have is, can a referee, in other words, a subordinate judicial officer does that person have the power to sign a warrant?
I would say probably, I think Constitution's gotta be a magistrate, right? That's a constitutional officer. I'm not sure if a commissioner can sign a warrant. I don't know.
The sister of it was on appeal, that is to say, they said, look, section 252 and 253 of the Welfare Institutions Code require that the person be a quote-unquote referee. That was 243, I'm sorry. That requires it to be a referee for them to be able to hear cases having to do dependency. But I would think that there would have to be somebody that's elected that can order a child removed.
I haven't looked at that issue, and I don't know how to answer that question.
I think the answer is referee does not have that power because referees are basically employees of the court. They are not judicial officers.
Yeah, that was sort of my gut
And
feeling.
there's a specific requirement that the disposition order, detention order, disposition order removing the child from parental custody be signed by a judge.
Yeah.
Which suggests to me that a warrant can't be signed by a referee.
Then
Or
I would
probably a
suggest to
commissioner,
you-
either.
I would suggest to you, if that's true, that your issue about warrantless removals being a thing of the past is completely wrong, because there are more referees than there
Well,
are police on a dog.
this is gonna be the issue, though. There's still a warrant, and facially, from the perspective of the worker, remember, whenever we're looking at a warrantless seizure claim, the question is, me, as a reasonable worker, with that warrant in my hands, is it facially valid?
Well,
So that's the question when you're looking at the county. What you're talking about would be an injunctive relief action against the court to force the court to actually use a constitutional officer. That's a different
just another
ballwax.
basis for liability.
I don't think that necessarily would be a basis for liability on the part of the county or the worker because they have a facially valid warrant. It's gonna be an issue with the court, which is the state, which has 11th Amendment immunity. So the only thing you're gonna get there is an injunction. At least without doing further research on it, I don't think you're gonna get any money out of that. You may get attorney's fees, except that the state is not subject to liability under 42 U.S.C. section 1983, so you're gonna have some other avenue to approach that issue. It's not gonna be, I don't think, a civil rights action. Okay, the next one is under color of state law. This is private actors. We talked about this a little bit at the beginning. This is the slide that addresses it. There's 4 basic ways to get it. It's pretty straightforward. I don't know how much time you guys want me to spend on it. It's everything I know about is basically on that slide. So, yeah. Oh, there's one thing that is important. And this goes for not just private entities, but also municipalities. Is remember, we talked a little bit about qualified and absolute immunity. That's personal to the individual you're suing, so the human being that is a defendant in your case. They have a potential to raise the defense of qualified or absolute immunity. Does not apply to municipalities or private entities engaged in traditional government conduct. So what that means is, although your worker, let's say on the issue of hospital holds, that's a good place to go because there's a recent case out of the Ninth Circuit. It's Kirkpatrick versus, I think, Washoe County. And what happened there, it was a hospital hold. Seized the kid from the dad at the hospital. It was non-offending dad. The issue there, though, was dad wasn't sure he was the dad, so he wasn't really excited to commit to taking care of the kid. And what the Ninth Circuit said, okay, look, under this circumstance, since we don't have clearly established law under this specific factual circumstance, we're going to blow out the claims against the individuals on qualified immunity. Remember, to get past qualified immunity, the law you're dealing with in the area has to be so clearly established that any reasonable worker would know their conduct violated the law. So we're always looking at clearly established. And when we're looking to determine whether or not a rule of law is clearly established, we have to look at the contours of the law in the specific circumstance of the case. And Kirkpatrick, what the court found was, well, we really haven't faced this situation before, so we can't really tag the social worker because they couldn't reasonably have known that under this circumstance they'd be violating the dad's rights. And so they blew him out on qualified immunity, but they went on to say, with respect to the baby, And the government doesn't get qualified immunity. There's an old concept, they just sort of readdressed it in Kirkpatrick. The government doesn't get qualified immunity, and we find that, yeah, the seizure violated the baby's rights. So, case went back down, I think it's in the trial court, they may have resolved it by now, I don't know. But the basic rule from that is, even if your social workers get qualified immunity, that is not the end of your story. You still potentially have a target on where you're gonna get the real money anyway, and that's out of the government. Yeah, this is fees. We've talked about that. We've talked about the standard that applies in fees. This is the reasoning behind it. We want to encourage people to file these types of cases. So we want to give big fees, and they do. They do typically give big fees. Fully compensatory fee. You can read that. That's all readily available in the, in the case law. And there's actually practice guides on how to make fee application and stuff like that. Reasonable fee, analytic framework. You guys want me to go into this? This is stuff not necessarily related to the substance of the underlying claims. It's how you collect your fees at the end. And that presumes you win. You get a positive judgment or verdict. And the rules are pretty well defined. And generally speaking, what the state court, if you file in state court, the state courts, it's sort of neat how they do this. They'll pick and choose the pieces of federal 1988 law that they want to apply, and then pick the pieces that they want to apply from state court. That's how you get an easier multiplier in the state court. They'll apply like the Serrano line of cases or Moses v. Ketchum to get your multiplier on your federal fees. And that's fairly standard. It's up to the discretion of the court. If the judge hates you at trial, you're going to get screwed on your fees. That's just the bottom line. Yeah, so you went to, it's a fine line, because your primary target, at least for me when I'm at trial, is I want to win, all right? And I'm going to do what I need to do to win. Now, if the other side doesn't object, that's great. You get to do what you need to do. If you go too far, maybe sometimes the judge will jump in and object for him. If that happens once or twice, maybe not a big deal. If it happens repeatedly and you end up pissing the judge off, remember, this is the same guy that's going to be ruling on your fee motion later. And there's been circumstances where, maybe, went a little too far and got a great verdict, but I paid for it on the fee motion. And, you just have to decide, it's a trade-off. Are you going to risk losing your case to make the judge happy, or do you just go, all out and do what you need to do to win? My view is I'd rather win and deal with whatever the issues are in appeal. That's a different process. The presumptions are more or less in your favor as a winning plaintiff in a jury trial on appeal, unless there was some crazy error. And, I'm willing to take a hit on the fee if it means that I won the case and got the client a good result. But it's a personal call. You gotta just decide what you're gonna do. The analysis they apply both in state and federal court, doesn't matter which one you're in, it's gonna be the lodestar analysis. Really simple. They look at the forum community, what's the reasonable rate for similar services of attorneys of equal or similar talent, skill, experience, reputation in the community. And doing that, they will look at prior fee awards or declarations of your peers saying what they think you're worth. That's all admissible evidence. And but typically what happens, you put in all this work, get all this great evidence, maybe even hire a fee expert, which I don't necessarily recommend doing because it doesn't do you any good, because the judge then gets to temper all of your evidence with his personal experience from the bench and his knowledge of rates in the community, which means it's really up to the judge. It doesn't matter what evidence you or the defendants put in front of him. The judge is going to give you what the judge thinks you should get. And it's discretionary. The appellate standard on that, it's abuse of discretion standard, but the way they phrase it is that the judge will not be reversed on appeal unless he is clearly wrong on a fee motion. And that's a really tough standard to meet. Same with respect to multipliers. It's totally discretionary with the judge. He was there at trial, he saw your performance, he saw the result, or she, and they either think you deserve a multiplier or not. You're typically not gonna get that reversed on appeal unless they just don't do the analysis. This is a quote I like. It's really cool, because what's gonna happen in all of your civil rights litigation, the government's gonna fight like hell. They're gonna hit you with every possible discovery device, they're gonna file every motion, they're gonna oppose everything you do, they're gonna object to all your discovery, you're gonna have to compel them. It's just constant battle. You'll spend thousands of hours getting one of these things to trial. But then when you get to your fee motion, the other side invariably will come up and say, hey, they overworked this thing, man. You know, you get the reasonable rate, but you only get reasonable time. And the time they're spending is, I mean, look at all this stuff they did. Well, the quote here is really cool. It's up on the screen. A party can't litigate tenaciously and then be heard to complain about the time necessarily spent by the plaintiff in response. Great. That's great stuff. The judges like it, especially where you had a defendant that's really obstructionist, which most of the government defendants are. You get to come right back out and say, hey, I wouldn't have had to do the work, Judge, if these boneheads hadn't have done everything they did. And so that usually works. Sometimes not. Sometimes not. If you pissed off the judge in trial, you know, you got problems anyway. You're in trouble on different levels. Yeah, the lodestar, once it's determined, that's the presumptive reasonable fee. So they go through an analysis, they'll say this, and they'll do it separately. They'll say this is your reasonable hourly rate based on whatever he's going to base it on. These are the reasonable number of hours. And the way you get your reasonable number of hours, you all need to keep accurate fee records. A lot of personal injury guys don't, because they're on contingency basis. When you get into this area of work, your fee is not going to be driven by the contingency. You may still get a contingency fee, and there's issues about reducing it if you get a verdict and a fee award, but it's still there. But if you want to recover a good attorney fee, you need to keep records, and the records need to be kept with sufficient detail to allow for meaningful review. That means it needs to be the timekeeper, whoever it is doing the work they were doing, a description that's adequate so that somebody who doesn't know about your case can look at it and say, oh, okay, I see, yeah, they spent 2 hours researching a meet and confer letter on some issue, right? They need to be able to conduct a meaningful review of the hours that you bill. And then obviously you have to have an accurate time entry. We do our time entries in real time, so it's going to be the actual time spent. A lot of places will round up to like a quarter of an hour or a tenth of an hour, whatever it is. If you're computerized, which I suggest you all be computerized if you're going to do this work, it's easy to just keep real-time records. And then when the judges see like 0.03 hours on something, it lends a further air of credibility and legitimacy to your time entry. So you'll end up benefiting in the long run if you keep good time records. Yeah, what else we got? Yeah, the enhancement factors that's on the slide: novelty, difficulty, complexity, capability of counsel. This is all stuff that's readily available in the cases and practice guides. And then the purpose of the lodestar enhancement, again, we want to encourage people to file these types of cases. Civil cases, civil rights cases, remember, Supreme Court tells us they belong in court. We want to encourage people to file them, litigate them tenaciously, and where need be, try them. And so what we do, I put together a list of cases where some pretty substantial multipliers. The highest multiplier I've ever got was out of Orange County. It's 2.5 times multiplier. For the trial work, got a 2.0 multiplier for the appeal. But here you can see there's some pretty serious multipliers. And these are federal cases, so it's a higher standard. But up to 10 times the fee, 5 times is reasonable. So that could be big money if your hourly rate is $5.50 an hour, which is not uncommon in these civil rights cases, and you get even a 2 times multiplier. That's big money, right? It's $1,100 an hour, and you can easily devote 1,500 hours, 2,000 hours to one of these cases, depending on what county you're fighting and how hard they're working. So it can end up your attorney fee. That's why I was saying earlier when you're talking about the technical violation. Kid gets interviewed at school, doesn't necessarily suffer any emotional injury or anything like that. you know, it's a question. If it's a clean case, clean liability case, you may want to go ahead and pursue it and take it all the way to trial. It's up to the county to, you know, come up with a reasonable way of resolving the case if you have a clean one. And a situation like that, you might demand, say, a policy change or additional training, you know, non-economic remedies. And courts love that. You know, you're in there, you know, really trying to change things when you're asking for a policy change or training as a condition of settlement. You know, you're only going to get nominal damages, so your heart's in the right place, right? You end up taking one of those all the way through, get a judgment or an injunction, or even a verdict. I mean, Bob, he did that Taylor case down in San Diego. He got a $1 verdict, but his fee for it was $550,000 or something like that. And so they're, you know, and it got a policy change too. The county ended up after that verdict, 'cause they're going to get hit. As soon as that thing came out, everybody's going to pile on. So they just immediately said, okay, stop. We can't be seasoned kids for pot. This is over. Just knock it off. But that's the effect of it, and the courts recognize the value, the social value in pushing those rights, even though there's not substantial money involved. And the judges will pay. They'll pay you for it, so you're not going to go uncompensated. With that, that is my last slide. So I guess I should cut it down a little further. So I don't know how to turn this thing off. Oh, here we go.
Sean, this is really a full day training.
Yeah,
Thank you.
I could easily have, I mean, we had, I don't know, probably 20 pages that we cut through. I don't know, some of it might have been duplicative because as we were going through things, covered it, you know, a little bit.